He did, yes.
Okay. I am not able to contact Ms. Anderson. The phone number we have on record is not a valid phone number.
And what number do you have for her?
We have
That's what I have.
okay. Mr. Cruz, can you hear me?
Yes, I can. Thank you.
Do you have a different phone number for Ms. Anderson?
I don't have that up right now, so I'm not sure if it's different or not. What was the number that you had for her? I can look in my file and see if I have something else, and I can try to call her at that number, or if I do have something, I can let you know.
Oh, I thought I was trying to talk to Mr. Cruz. Mr. Cruz, can you hear me? Ms. Anderson,
yes,
are
I
you
can
there?
hear you.
Okay.
Hello, can you hear me?
Yes, Mr. Cruz. Do you have
Yes.
a current phone number for Ms. Anderson?
The 3 number is the only one I have.
Okay, that's all we have also. Okay. I've tried to call her and I've sent her an email. I don't know what more we can do, so I will let the judge know that we're ready.
Okay, thank you.
You're welcome. Judge Pullan will be joining us in just a few moments.
Thank you.
Michael, are you there?
I am. Good morning.
Good morning.
We are on the record.
Very good. We'll go on the record in the matter of Anderson versus Cruz. Counsel, would you state your appearances for the record?
Your Honor, Todd Barth, and I have the respondent, Adam Cruz, who is also with us via telephone.
The State of Utah Office of Recovery Services intervener.
Great, thank you. Is Ms. Anderson on the phone?
And that the call-in user is Mr. Cruz. I have tried calling Ms. Anderson, and the number we have on record is that it's not a valid number. And I've also sent her an email with no response.
Mr. Barfus, what's your most recent contact information for her?
Your Honor, it was the same that your clerk confirmed. That's what I have as far as her. As far as any communication, it was by email, and it's been several months. If you'll recall, we've had 2 previous hearings related to this matter, which she has also not appeared for. She did respond to the clerk's email scheduling this hearing, so I don't know what the problem is. But given the history that we've had in this case, it just seems like she's checked out, Your Honor, and I think it goes to support what we're asking for in this matter, which is a reversal of the recommendation of the commissioner on a 50-50 custody basis. We've established in previous filings a history.
Sorry, before we get
I was
just
launching into my merit.
let me make sure that we use the most recent contact information that you have. What do you have on her number and email?
I have 801-372-3097.
And that's what we have.
We have.
And that is the number that I called.
And the email.
I have NicoleAnderson@gmail.com. I'm sorry, NicoleAAnderson@gmail.com.
And it's with the E, Anderson, S-E-N with the E. And
That's
Council
correct.
was correct. She did respond to the email setting up this hearing. I've sent her a reminder from WebEx, an email, and I've also called her.
Your Honor, for what it's worth, those numbers and email are also what is on the ORS record as well.
Okay. Thank you very much. And we've tried to call her this morning, Michael.
Yes, and it was an invalid number. Would you like me to try it one more time?
Would you do that?
In fact, I'll try it from my cell phone so that
Thank you.
okay, I am calling 801-372-3097.
Your call cannot be completed at this time. Please try again later.
Okay. No success there, Michael.
No, did you hear that, or was I muted?
No, it just said the call can't be completed
Right.
at this time. Not exactly sure what that means. Did it?
I don't either, and I double checked the number again, and it was the same number, 801-372-3097.
Your call cannot be completed at this time. Please try again later.
Okay. Thank you, Michael.
And I also did it from the court system as well, the court phone system, so I know it's not my phone.
All right. Thank you so much. Does the state of Utah have any interest in the objection to commissioner recommendation?
Your Honor, we have not filed anything. This matter has been between the parties regarding the custody. We do have an open case regarding the parties, and we would want to make sure any orders are consistent. I don't believe there's been any child support orders yet in this matter, just only the issues of custody. So I don't think we have a whole lot of interest. We may participate in case the court or the parties raise matters that pertain to us, but otherwise we don't have an objection to the pending motion. We leave that up to the mother to respond.
Okay. Thank you. And counsel, you did file the notice to appear or appoint, correct? I think you're muted there, Mr. Barfus.
Apologize, I don't know how that happened. Yes, I did send her. I can get you a date on that, but I know it's in the file.
Yep, I think I reviewed it this morning. So,
Judge, I just received an email from Rachel Olson. She is Commissioner Ito's clerk, and it is from Nicole Anderson, dated February 23rd at 8:08 p.m. Would you like me to read it or just forward it to counsel?
sure. Would you just read it to us? That will probably be fastest. Is it
Okay.
long?
Yeah, it's 3 paragraphs.
Yeah, go ahead.
Hi, Rachel. You have helped me before with my case, and I'm so sorry to email so late, but I'm not sure what other options I have. I currently have a hearing set for tomorrow with Judge Stone, I believe. I'm still working on getting legal help to represent me, but because my previous attorney still won't withdraw, they cannot sign on to my case. However, they recommended I contact you because they are not allowed to contact the courts on my behalf or give me excess details on what to do. Anyway, I was planning on attending the hearing and letting the judge know this tomorrow to see if we could extend things. But I got an email around 7 p.m. tonight for an invitation to a job interview at the same time as the hearing tomorrow. I've been out of work because of COVID and haven't been able to find any employment that would so much as email me back. because it's extremely important that I can't miss this interview. Of course, I don't want to just not show up to the hearing. I know this is probably an ask that is not possible, but if the court could reschedule the hearing due to the job interview, I would be grateful. None of this would be happening because my employment paid for an attorney, but with the pandemic, I'm in a very tight spot. I understand you also most likely won't receive this email until after the hearing, but I'm hoping it will at least explain my absence.
Okay. Thank you.
I'll make it a part of the record.
Yeah, if you would just put that into the document.
Your Honor, I've just been notified by my client. We have concerns with that statement. My client tells me that Nicole picked up the daughter this morning at 9 o'clock, that he personally walked the daughter out there.
Mm-hmm. Okay, thank you. So, Michael, we have that in the docket, right?
I'm putting it in there right now.
Okay. All right. Mr. Barfus, let me hear from you. I'd like to know how you'd like to proceed today.
Your Honor, we would like her objection to, well, her opposition to our objection to be stricken. She's been given so many opportunities to appear, including on the issue that we've raised previously that was before you on the order to show cause for failure to move forward with the custody evaluation, which she was the first to move this court for. She's had several months to retain new counsel. That was her objective. She's also seems to be putting priority of another case matter before this. We just see that this has been a pattern. We feel that we objectively proved always been that for the child, and we're submitting to the court that the commissioner should have ruled at the time, and we're asking for now to change from a 50-50 custody scenario, which has not been in the best interest of the child, to one of 30-3-35.1. We'd ask that to be the record, that child support be altered consistent with that changed parent time schedule, and we're ready to go. We'd like to schedule a pretrial conference, and if she's not going to appear to that, we'd like to have her answer or her initial pleading stricken.
Have you filed a counter petition for? I can't remember a counter petition for divorce that you were ready for entry?
Yes, Your Honor, and I had intended, depending on how this went, to file a motion to bifurcate, because if she's going to continue to delay this matter in her failure to appearance, we would just like to have it. If we can't resolve the total matter easily, we'd like to have the divorce bifurcated so we can go to trial on the issues that are still in dispute.
Okay, that'll be for another day. But what I'd like to do today, I've spent a lot of time preparing for today's hearing, reading all of the papers filed in support of the motion for temporary orders. All of those papers were timely filed and placed before the commissioner, important evidence related to the custody of the child, and for that reason, I'm going to deny the motion to strike Ms. Anderson's papers. It's more important that, again, I do that because Mr. Cruz had full and fair opportunity to respond to those. They're properly before the commissioner and properly before this court, and I don't feel like I can make an informed decision about the best interests of the child, without considering all of the properly filed evidence before me. I do, and so I have read all of that. As Mr. Cruz requested an evidentiary hearing, does he intend to testify today, or how would you like to proceed given that.
Your Honor, I'm fine with proffering, but I'm fine with putting my client on the record. His testimony would be consistent with that which we filed with our verified counter motion and responses. We've submitted significant evidence, which I'm sure that you've reviewed in your review of this case with regards to missed parent time. Also the temporary separation order where the parties had agreed to the custodial arrangement. Your Honor, one thing that was not submitted in our last hearing was petitioner's ongoing mental health issues. My client would testify that she was hospitaled in December of 2009 for a suicide attempt. Our concerns
in 2009?
2019, Your Honor. So it would have been right before we had the hearings before the commissioner.
Could I just maybe focus our inquiry? I do have some questions for you, and maybe you can proffer or put Mr. Cruz on the stand. The temporary separation agreement expired in October of 2019, correct?
It did, Your Honor.
And you know, that agreement, the issue before the court was Ms. Anderson fraudulently induced to sign the agreement? She claims she was. Your client says she wasn't. It seems like the evidence is evenly balanced on that question. I don't know really how I would discern who to believe there. It's a he said,
well, Your Honor,
he said issue. And if there were promises made that this wasn't really going to change anything, that she didn't, you know, it was just to get something more formal in place, and you know, clearly that those sort of representations would breach the fiduciary duty provision of the temporary separation agreement. And so that's one issue that I'd like to know more about. The other real concern that I have is it appears that after the temporary separation agreement expired in October of 2019, that your client really just cut off parent time. And I've read the text messages. He says, you know, there will be no parent time unless until we reach an agreement. And I don't understand that. I don't know why your client would cut that off or require parent time to be supervised. There's no evidence before me about what was going on at that time that would even justify such a thing. And your client's apparent willingness to use the minor child as a kind of bargaining chip to get mediation arranged is very concerning. So those are the two issues that I think really I wanted to hear more about, because I may not fully understand what's happening.
Understanding what happened since the end of the temporary or separation agreement.
It appears that your client cut off parent time with mom in October of 2019 and just said, well, there will be no exchanges. His text, I think, says there will be no exchanges until we get an order in place. And I don't understand why he would do that.
And Your Honor, and I'm fine with questioning my client on the record on that. I believe our responses back then were the same as his would be today. Since it expired and we had not had a set time to go to mediation, nor did we have a court date, from my recollection, my notes, his attempt was simply to have an agreement in place that they could continue to rely upon the parent time schedule that they had agreed to, which he maintains was mutually agreed to as far as the temporary separation order, that was not challenged by Ms. Anderson after it was filed and for the year that it was in place. If she was claiming that there was some kind of fraudulent inducement, she did nothing in that year's time, but she would refuse to engage in even having a temporary agreement before we could get to court to where we had something that was enforceable. I don't believe he cut off.
I'm sorry, I understand that there was a disagreement about what it should look like, right? What parent time should look like. But it appears from the evidence before me that he just withheld the daughter until he got what he wanted. And hence we have several months that pass with the child not even seeing mom.
And my understanding, what I would argue, and I'm happy to question my client on that, is that he did not withhold his daughter. He was simply looking for an agreement from mother that she wouldn't take the child and fail to return her, which she had threatened to do in the past.
So he did withhold her then, right? He didn't allow the daughter to go see mom.
Your Honor, it's my understanding he did not withhold her.
Well, maybe this is semantics, but the upshot of whatever decisions he was making is that daughter did not see mom for several months after the temporary separation agreement expired. And possession is not 9/10 of the law when it comes to children.
I'm sorry, I didn't hear that, Your Honor. It cut out.
I'm sorry, possession is not 9/10 of the law when it comes to children. So
I absolutely agree with that, Your Honor.
let's have him. These are the areas. You know, when I look at the commissioner's decision, it would seem to me that it may be in the best interest of the child, especially if Mr. Cruz is actively withholding the child and damaging the relationship between the child and mom. And then more time with her will be needed to compensate for that interference. And based on what I've read, it appears that that's what he did. So I'd like to hear testimony about that. I'd like to hear testimony about he claims that he didn't fraudulently induce her. I'd like to hear what his side of that story is as well. And
Your Honor, how would you like to go about that? I'm happy to
let's have him sworn. And
okay.
I have a 10 o'clock hearing, so let's get right at it.
Okay.
Mr. Cruz, if you'll raise your right hand, take an oath to tell the truth. Do you solemnly swear that the testimony you're about to give in the proceeding now pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, counsel.
Your Honor, how would you like me to proceed with questioning?
If you just inquire on those two topics, I may have some.
Okay. Adam, can you hear me okay?
Yes, I can.
Okay. Let's first talk about the circumstances and events surrounding the agreement and the entry of the temporary separation order. Can you remember the date in which you guys originally separated?
January 24th, 2018.
Okay. And whose decision was it to leave?
Nicole.
And did she leave voluntarily?
Yes.
Did she ask to take your daughter with her?
No, she did not ask to take me with her, or as to regards as to what time she would spend with her when she left. No.
So she just left the house. Do you know, did she leave the house for another relationship?
No, she did not.
Okay. She just left.
Correct.
And at this time when she left, who was the primary care provider for your daughter?
I was.
Okay. And who initiated the conversation with regards to a temporary separation order?
I did.
And what was, how did you go about that?
There was conversation escalating in regards to going to court and trial, and I had suggested to her, based on my research, that she could file a temporary separation agreement that we could put on paper with accountability and put down an agreed schedule so that I know when I would expect her and to pick her to pick Mia up and also when to drop her off. Again, the basis of that agreement was also that Mrs. Anderson was very inconsistent with her parent time. She would not give appropriate advance notice as to when she would pick up. She would often very last minute cancel. And I'm talking like my daughter is dressed and ready to go and she sends me a text that she's not going to make it.
Okay.
So because of that pattern and also the escalation of threats to go to court and argue this and that, I suggested, okay, in order to transition into that smoothly, I looked it up. You can file a temporary separation. We can file a temporary separation agreement, but that we can draw up without attorneys. We can draft it, resolve our concerns, and file it.
Okay.
And, yeah.
And that document, who prepared it? Did you prepare it? Did she prepare it, or do you guys do it together?
She continued to evade the responsibility of drafting anything herself, and in an email, she asked me to do so. So I did. I drafted the document and edited it several times after her reviews and input. And when it was finalized and we agreed on it, we set 2 dates to meet at the Utah County Courthouse in Provo. The first date she bailed, something came up and she canceled. And then the second time she showed up with her, at the time, boyfriend. So she was with somebody to like kind of help her through the process. Like, you know, if she needed to talk to somebody, somebody was there. If she had any doubts or concerns. And
but to clarify, it sounds like you drafted that agreement together. If you sent her and she sent back revisions and you made revisions, then that was a jointly drafted document, correct?
Correct.
Okay.
Yeah,
so tell me about this second
time.
Tell me about this second time at the courthouse. She showed up with a friend or a boyfriend at the time?
Correct. Yes, she showed up. Things were very amicable, and we were able to sign the documents there in front of the clerk and file them. She didn't have any questions. I had asked her to pay for the fees, and she did. And we followed the agreement for a year until its expiration date.
Did you make any threat or promise or inducement for her to sign that agreement?
No.
You didn't promise her that things would change or be different?
Correct.
Okay. And during the course of that year in which the temporary separation agreement was in place, how did things go as far as custody and parent time?
So I had made the draft and she agreed to it based on my experience and understanding of the Utah Code 30-3-35 and 35.1. And so for one thing, like I didn't include holidays. I didn't think that we would have the temporary separation for even the whole year that it would expire. Even after the whole year and it would expire. You know, I expected that we would try mediation a couple times, something, and hash it out. And that was primarily based on the fact that Nicole Anderson was with me while I spent many years and fighting in court for another custody issue. So
okay, but let's get to. What I wanted to know about was.
Cruz, sorry, don't talk over each other. I'm having a hard time hearing. So, Mr. Cruz, just when your attorney begins to question you, just stop. Okay, go ahead.
Yes.
Adam, what I'd like to hear is a report on how the custody and parent time went during that year that the agreement was in place. Did she honor that agreement?
Okay, I can answer that. Nicole Anderson did not honor the agreement. There were many dates that she did not pick up and have. Yes, in what way? Nicole Anderson did not show up on time or even the whole time. She would just cancel the allotted parent time that she was to have with Mia. Several times she would text or email last minute, and very often she would not email, call, or text at all. I would have to follow up and say, so you're not coming?
Okay.
And,
so
and she never asked for any makeup time or anything to
Adam,
to switch it around and make up for it.
Can you hear me, Adam?
Yes, I can.
Okay. So as you got closer to the end of that year, what were your communications with Ms. Anderson regarding parent time after the expiration of that agreement?
My communication was that, if we don't have anything agreed to beyond and extending the expiration date of the temporary separation order, and we have nothing to hold each other accountable to because of her behavior of missing parent time and pattern of telling me lies and so forth, then in the best interest of our child, we can't continue with parent time. I'm not withholding parent time because there's no agreement.
Did you offer parent time to her after the expiration of the temporary separation agreement?
I'm sorry, you broke up. Would you repeat that question?
Did you offer parent time after the expiration of the temporary separation agreement?
Yes.
Tell me about that. What did you offer her?
Simply, I said, hey, let's go to mediation. We don't even need attorneys, and we can go to mediation and with a professional figure out a schedule that works, like whether it be the same or, something a little bit more if you want.
And so if I'm hearing you right, Adam, you said you offered her the same parent time that you guys had in the temporary separation agreement?
Yes.
Did she accept that offer?
No.
What was her response?
I don't think there was much. It was just, I don't recall a response. I think it was just, I'll see you in court kind of a response.
So you made an offer for parent time. Did she request parent time that you refused?
No, not that I recall.
Did she show up for your...
Let me just, are you telling me, Mr. Cruz, from October of 2019, so let's say the 6 months following that, you're telling me that Ms. Anderson never requested time with the child? Because that is inconsistent with the paperwork that I've read.
As I said, I don't recall her texting or emailing for parent time. We were talking about court and mediation.
Why didn't you just continue with the temporary separation order and allow the child to see her mom until you guys work this thing out?
There was no agreement.
Well, Adam, let me go back because I think we're confusing our conversations. I just asked you what parent time you offered to Nicole after the expiration of the temporary separation agreement. And correct me on my dates, was that October of 2019 that it expired, the separation agreement?
Yes, I believe so.
Okay. So in or
I
around
don't have the email
October,
or date
right?
of temporary separation in front of me exactly.
Okay.
So
But in or around October of 2019, did you offer to maintain that same parent time agreement with the respondent?
in October?
Any time after the temporary separation agreement expired, did you offer or propose to maintain the same parent time schedule with Nicole after that agreement expired?
I'm sorry, I don't understand the question. So between, like, just after October 2019?
Whenever the date was, and at the time you would have known it, but when the temporary separation agreement that you guys signed expired, that had a parent time schedule, did you propose or offer that same amount of parent time to Nicole once the agreement expired?
Yes.
Yes, you did?
Yes, I did.
And counsel, maybe we can just get to this.
And what was
I'm sorry.
Sorry.
I think we're just talking past each other. He offered one thing, she wanted something else. And so there's this disagreement. And my question is, so they disagreed. Was there any parent time that was happening notwithstanding the disagreement until, that's my concern, is that he offered one thing, she wanted 50-50 back. That's what the emails seem to indicate. And so they're at an impasse. Did your client just say at that point, well, until you agree with what I want, you're not going to see the daughter?
No.
That's what I'm trying to get at. Mr. Cruz, did that happen?
No.
What efforts did you make to allow mom to see the daughter after the temporary separation agreement expired?
I encouraged her to come and visit at the home. I encouraged her to spend time with her. I encouraged her to FaceTime. Absolutely. I encouraged her to meet with me in mediation at a minimal cost so that we can, again, agree on something temporarily, understanding that we have shortly at the end of 2018, we knew that we had a court hearing date in January. And I said, let's meet and agree on something.
So
we were at an impasse.
Why did visits have to take place at your home?
Because of her pattern of lying and mistrust. It goes to show that in December she was hospitalized for a suicide attempt.
All right, Adam, we don't have records on that, but let me ask you this, because I think it's what the judge is trying to get. Were you wanting to limit Nicole's parent time with your daughter to only happen at your residence?
No.
Meaning, would you have allowed Nicole? I understand you guys were trying to get to mediation and it didn't happen, but did you deny Nicole the opportunity to have parent time in her home after the expiration of the temporary separation agreement?
Yes.
You did deny her.
No, I'm sorry. I think your question was fairly heavy loaded, so I don't know. So
well, I'm trying to answer the judge's concerns in whether you were trying to control parent time to keep it only in your house where you could witness Nicole, or whether there was a true offer to have her continue parent time that you had under the temporary separation agreement, but after it expired. The judge is asking, why certain parent time didn't just continue at the same level after the expiration of the temporary separation agreement. I understand you were trying to get mediation, you were trying to get another agreement in place, but we're trying to find out what efforts you made to facilitate parent time after the expiration of the temporary separation agreement. Are you still there?
Yes, I'm still here.
Did you hear my? It was a long question, but did you hear my question?
Yes, I did. And I'm just struggling in the sense of how to answer it from my personal experience and what I did to facilitate and encourage the relationship between my daughter and her mother to satisfy the judge's concern.
Well, I'm not looking for you to answer just to satisfy. We're looking for truthful answers. And if I could maybe, with a sidebar with the court, I would note that it was my client who encouraged Commissioner Ito.
I'm sorry, I don't want. He's on the stand right now, so I
Okay.
just want to hear his answers, and then we'll hear argument based on the factual testimony. Maybe I can just get at this. Mr. Cruz, it seems to me that based on your testimony, you operated for a full year under the temporary separation order, the agreement that you had, and that was fine with you. And then suddenly in October, you tell mom, oh, now parent time has to be supervised in my house or by FaceTime. And I don't understand that. Why did suddenly parent time have to take place in your home?
Your Honor, may I answer your question?
I would love to hear your answer. Yeah, go ahead.
During the period of a year with that separation order in place, the petitioner behaved in a way that was not conducive of co-parenting nor of showing best interest of the child.
I'm not sure what that means. So you're going to have to help me.
It means that she showed that she didn't care about her daughter.
How?
She wouldn't come and spend time with her. She wouldn't come when she had agreed to do so.
Okay.
She violated her own agreement.
Okay.
She broke her own agreement.
And in the paperwork, you should point to 12 times that happened, right?
At least 12 times, yes.
Okay. So she was inconsistent in exercising parent time. Anything else?
In regards to the separation agreement, that had an expiration date. Within that agreement was parent time. There was a contract. We agreed this is the parent time. And we agreed that if we don't follow this parent time, that we could follow the Utah code and we could go to the police and explain that we have this agreement, and that if we violate it, it would be custodial interference. Your Honor, that agreement expired on October 2019. So if there was an issue with me, in your words, withholding parent time, that would be custodial interference that should go to the police to, but that was not the case. There was not an agreement. We did not have a set schedule.
So did you feel like
any attempt to try and create it? I'm sorry, go ahead.
Mr. Cruz? Yeah, it's all right. I thought you were done. So was it your position that once the parent time agreement expired, that you could just keep Mia?
My position as her father was to do all I could to protect her and to encourage her relationship with her mother. And the means that would be possible with at the time was FaceTime and in my home, and also by going to mediation or getting something temporarily agreed so that she could see her and we could be held accountable to.
Okay.
She was a risk. Mrs. Anderson was a risk. I didn't know where she was living at the time. She told me she wouldn't give me the address of where she was living. She had taken several out-of-state trips and telling me several times of how she was interviewing in this state and that state. And the whole time, I could not believe her. She has a pattern in history of not telling me the truth. And that is even evident within the last 24 hours when she sends an email saying she has an interview and she's at my door at 9 o'clock at the same time that she had said interview.
Okay, counsel, thank you. Go ahead if there's anything more.
Adam, did Nicole ever threaten not to return Mia because you guys didn't have an agreement? Adam?
No, she never stated a time that she would pick her up or drop her off. No, she never asked for a time.
What I'm asking is, did she ever make threats of taking Mia for parent time and then just not returning her?
Yes.
Were you afraid that if you gave her custody without some kind of agreement or understanding that she would not return Mia?
Yes.
When did that happen?
It happened before the temporary separation agreement.
And what did she say?
It was over, I think summer of 2018, and she was making claims and of what she can do with Mia, and she had said in ways of how hard she could make it for me, understanding my history, and that she's gotta let Mia go with her, and she doesn't have to tell me when she's coming back, things like that.
And let me ask you this: that she had taken trips out of state and was interviewing for jobs out of state. Were you ever afraid that she would take Mia and leave the state since you guys hadn't filed divorce yet and there was no agreement in place?
Yes.
Why were you afraid? Why were you afraid of that? What's the basis for that fear?
Because she was eliminating her ties to the community and to the state. She had lost her job. Her mental state was in question. She was never telling me the whole truth. She was telling me that she was going here, going to this state and that state, and I mean, I think even at one point she made that a reason of why she couldn't see Mia, our daughter.
Adam, let me ask a question about your memory.
Showing the means. I'm sorry. If I could just finish. She was showing the means of the ability to travel and go out of state and do this and that and not have a reason to come back. I mean, she was considering taking, as she said, she was considering taking a job out of state. So,
Okay.
if that's a lie. How is that in her interest?
Adam, let me ask you this. Once the temporary separation agreement expired, how many times did you try to get together with Nicole to reach an agreement so that you guys could both continue on with some kind of parent time schedule?
How many times? Is that your question?
Yeah, between the time the agreement expired and when we knew we were going to go to court again for temporary orders, how many attempts did you make, Frank? Get together with her to get an agreement, either through mediation or otherwise?
At least 5
Was
times.
it once?
No, it was multiple
And
times.
how did?
I'm sorry, he said at least 5 times. Go ahead.
And was this through email, telephone conversation, face to face?
I recall this was through email, text, and counsel.
Okay. And was she receptive to any type of offer?
No.
What was her response? Come to an agreement.
I'm sorry, you broke up there. Would you repeat your question?
What I mean, what was her response to your request to get together to discuss an agreement?
I don't recall much of a response beyond no. I believe
She didn't give any reason
No,
for not
she
wanting to
didn't.
get together?
She did not give any reason.
Your Honor, I'm open to any questions that you may have.
No, I think that helps me understand what the circumstances were and the reasons for Mr. Cruz's decisions. Let me just, I've got a 10 o'clock hearing. Let me just briefly hear your arguments about the Commissioner's recommendation, why you believe it's not in the best interests of the child. Really, there are 2 issues that are in dispute. One was his position as primary caretaker procured by wrongful action, and then second, what's in the best interest of the child. I'll just hear you briefly an argument on those issues.
I'm sorry,
those are yours, right? In the objection to Commissioner recommendation, you take issue with those 2 findings that
I think yes. I think the court overlooked or misstated how primary custody came to my client.
right.
I don't think they relied on the facts on that, in that it was the petitioner who voluntarily left the house and soon thereafter pursued another relationship. She left the child in the care of my client, and the child remained in the primary care of my client for well over a year. During a year in which they had the agreement, there was several missed opportunities that were not forced upon or controlled by my client. Now, I think where the court focused mainly was the brief period of months in which the parties were back and forth saying, we need to have an agreement, no, it's my way or this way. I think that there's reason for confusion there because the clients were saying different things. But what I think is most important is the establishment of the status quo was not obtained fraudulently. there's no shown to be any, there's no emails or communications that shows my client was fraudulently inducing the petitioner to sign the temporary agreement. There was great distance between the parties, and I don't think the court necessarily took into account that. Most of the custody evaluations that I've been involved with indicate a difficulty when there's 30 miles or 30 minutes or more in between the parents. The child had already established an educational trajectory there in Orem, and the petitioner's the one that left. And so I understand that the court is grasping now with it's now a year removed. But another issue I have with that is we waited several months for petitioner to follow through on her request for the custody evaluation, at which time and in that venue we plan to raise all of these issues that went to the best interest of the child that we could show to the court. And through no fault of our own, that delayed things and pushed things out, and we find ourselves here. I don't think that there has been any fitness allegations made by the petitioner to my client, and we're not suggesting that the petitioner shouldn't have ample time with the child. We're suggesting that it should be under 35.1, Your Honor.
The difficulty I have with the argument, your client says, look, we live 30 minutes apart, and that's really hard for us, but the proposed schedule that you're asking for will actually involve more exchanges than what the commissioner's order does.
More overall exchanges?
Yeah. So how do I reconcile that?
My concern wasn't the exchanges.
Mr. Cruz, I think I've heard from you. I just need to hear from you right now. No, that's all right.
I didn't know I was muted. I thought I was muted.
These electronic hearings it's hard to know who I'm looking at, so no need to apologize.
Judge, I'll go ahead and mute him, so if you need to hear from him, let me know and I'll unmute him.
Great, thank you.
Your Honor, it looks like, I'm looking at the temporary order again. We have a 2-2-5 rotation. I don't understand, I guess, why that creates additional time.
Won't that involve,
but I don't.
Won't your proposal to go back to 35.1 involve more exchanges than the commissioner's order?
The 2-2-5 rotation schedule? I don't believe so.
Yeah. Maybe I've miscounted, I guess. I think you may have frozen up there, Mr. Barfus.
Oh, no, I'm sorry.
Yeah,
so,
I'm just thinking, how many exchanges would happen under 35.1?
Well, you would have
You're asking for the temporary separation order, right? That's what you want.
Right. Well, no, the temporary separation order, I think, had a little bit less time than 35.1, but I don't have that in front of me, so don't quote me on that. But I think under a 2-2-5 rotation schedule, you'd have 2 exchanges a week every 2 weeks, where under 35.1, you'd have 3 exchanges every 2 weeks. So it'd actually be less. But, Your Honor, I don't know if I see that as the mounting argument. I think we're more so relying upon the status quo, the educational trajectory having been established. My client, as the father, having shown history of being the primary caregivers dating back to 2016, Your Honor.
Okay. All right. Thank you very much. So give me just a minute to review my notes, please. Michael, are you there?
I am. We are back on the record.
Great, thank you. We'll go back on the record in the matter of Anderson versus Cruz. Mr. Cruz is joining by telephone. Mr. Barfus is here on his behalf. Mr. Walker, on behalf of the state. Ms. Anderson has failed to appear. She did contact the clerk last night indicating that she had a job interview today at 9 o'clock. However, Mr. Cruz has testified that at that very hour she was picking up the child from his home for parent time. I have denied the motion to strike the papers she filed in opposition to the objection to Commissioner recommendation, as I believe that they are properly before the court, and Mr. Cruz has had a full and fair opportunity to respond to those papers. Again, I wanted a more complete record about what is in the best interest of the child. To begin, the Commissioner found that Mr. Cruz's role as primary caretaker had been secured by misconduct, or was, I think the term was artificially created. The Commissioner found that for that reason, that a 2-2-5 split was in the best interest of the child. Having looked carefully at the evidence in the case, I'm not persuaded that the temporary separation agreement was the product of fraudulent inducement. I've read carefully the agreement. It actually references the fact that it's an integrated agreement, that there are no other promises made. The testimony of Mr. Cruz is persuasive about its execution at the courthouse, that occurred amicably. Ms. Anderson signed it voluntarily, paid the filing fee for it, and the parties for a year followed the temporary separation agreement without complaint. Therefore, the court finds by a preponderance of the evidence that Ms. Anderson voluntarily, knowingly entered into the temporary separation agreement. She was not fraudulently induced to do so, and Mr. Cruz's status as primary caretaker was not procured by misconduct on his part. The 2-2-5 arrangement approved by the court commissioner may ultimately be in the best interest of the child following trial. However, in the interim, preserving the status quo is for the child is more closely aligned with her best interests. For that reason, the court will approve on a temporary basis that Mr. Cruz be the primary custodian, subject to Ms. Anderson's right of parent time under 30-3-35.1. The court notes for the record that upon the temporary, and I do find that on the temporary separation, the expiration of the temporary separation order, Mr. Cruz unilaterally suspended parent time, upsetting the very status quo he seeks to restore today. There was a period of time where he indicated that the only parent time Ms. Anderson could have would be at his home, supervised there, or by FaceTime. His justification for this decision was Ms. Anderson having been inconsistent in the exercise of parent time, and then he's referred generally to certain lies that were told to him and mistrust. I'm not persuaded that those were sufficient justification for this unilateral suspension of parent time and insisting that parent time be supervised. There was no good reason for that other than Mr. Cruz attempting to gain strategic advantage in his negotiations for a more permanent agreement. This was a time of significant uncertainty for the parties, and I understand that, but I am gravely concerned about Mr. Cruz's willingness to suspend parent time between the child and her mother to obtain strategic advantage. And when this case is ultimately tried to the court will have particular interest in whether or not Mr. Cruz has actively facilitated the parent time to which Ms. Anderson is entitled. Any evidence that he is interfering with that parent time or acting unreasonably to obstruct it will be evidence that he is not a person who should have primary custody of the minor child. One of the factors that the court can consider in reaching a custody determination is the willingness of each parent to encourage a relationship with the other parent. And so I just note for the record that I'm going to be significantly interested in that issue as we move forward. For these reasons, the objection to Commissioner recommendation is granted, and I will look to Mr. Barfus to prepare the order consistent with the court's decision today. What I would like to do is get a sense of where we are in the litigation. Is the custody evaluator appointed yet? Do you still want one, or should we just try this case?
You know, we wanted previously to touch ahead. I believe the order stated that if payment wasn't made in a certain amount of time, that it was gonna that the custody evaluation was gonna be foregone. My client can't afford to pay for one, and I have no idea petitioners. And so I think I think the court could benefit it. I understand the time and the cost involved, but I think at this point, I don't know. I think it might be in the best interests of both judicial economy and for the parties that maybe we just set a pretrial calendar, because we're ready to move forward, I think, Your Honor, and I think the petitioner has shown that she's kind of checked out of this case. My client's interested in seeing it through to a conclusion as soon as possible.
Has that time to pay the custody evaluator expired?
Well, I don't even think the time has begun to run, because the petitioner has never submitted a proposed order appointing a custody evaluator. At the hearing where that was last addressed, there was some argument on her first proposed evaluator. We objected because we felt there was a conflict. We literally would have taken probably any other recommendation, and we proposed Todd Dunn. Petitioner never has responded. The one time she did respond, she indicated concerns regarding COVID and doing an evaluation during COVID. I just don't think that we'll get a proposal from her, and if we do, I don't think it will be paid.
Okay.
So,
thank you. With respect, Ms. Anderson selected the custody evaluator who had done work in your client's prior divorce, right?
that's correct.
Correct about that?
Yeah.
With respect to that custody evaluator, there is a conflict of interest, and I'm not going to appoint that evaluator. We need
Right, and that was Commissioner Ito's.
Yeah, and so this is what I'm going to order. Within 14 days, Ms. Anderson should name another qualified evaluator. If you disagree with that person, then you can propose your own. the court will select an evaluator at that point, and then within 14 days of the court selecting an evaluator, the evaluator's needs to be, the initial retainer needs to be paid. If it's not paid timely, then the right to a custody evaluator will be foregone, and I'd like to schedule this matter for pretrial conference 28 days out, just a little more than 30 days, Michael.
For just a pretrial, is that what you said?
Yeah, pretrial conference.
Okay. At 9 o'clock?
That work for your schedule, Mr. Barfus?
That works for me, Your Honor.
Great, and I don't know if the state has an interest at this point.
Your Honor, we probably do, at least at that pretrial, just regarding the ongoing child support case. I did have but that date would work for me. I did have one thing that I know you pressed for time this morning, but regarding the child support, it was ordered at 0 based on a partial stipulation and also findings from proffers at the last hearing that both parties' incomes were $12.57 a month minimum wage. That was a finding by Commissioner Ito. That resulted with the joint custody order as a $0 child support order. Also in that order, I believe paragraph 12 included all the statutory medical language. Given this order today, is the court ordering that beginning March of 2021, the next full month following this hearing, that mother's child support would be ordered consistent with the sole custody worksheet at both parties at $12.57 for one minor child, and is the court including the statutory medical language that was previously ordered?
On a temporary basis, it should be recalculated.
Chris, you asked the question that I was going to ask, and you beat me to it, so thank you.
Yeah, that's why Mr. Walker's here, is to make sure that those issues are covered.
I have one little area that I like, and I always bring it up, so thank you.
Yep.
You do it well. Thank you so much. Court's in recess.
Thank you, Your Honor.
Next hearing.
I'll be right there. Thanks.